As you know, the religious or religious practices they led to the very origin and development of untouchability in India. So, regarding that, we will discuss the very decision rendered by our Supreme Court in some leading cases, such as People's Union for Democratic Rights versus Union of India in 1982, and the second leading case, State of Karnataka versus Apuval Eagle in 1993, and another important leading case, that is N. Adityan versus Travancore Development Board, and it was a case of 2002, and where the Supreme Court expressed that religious freedom is subject to public order, health, morality, and other provisions of Part 3 of the Constitution of India, and which includes Article 17, and it also declared as protection of civil rights in the leading case, State of Karnataka versus Apuval Balu in 1993 by the Supreme Court. So in the leading case, People's Union for Democratic Rights versus Union of India, it was declared as violation of fundamental rights. And now we'll discuss another important leading case, and that is Adi Shiva Shivangalar Nala Sangam versus Government of Tamil Nadu in 2015, the Supreme Court expressed that the issue of untouchability raised on the anvil of Article 17 of the Constitution stands at the extreme opposite end of the pendulum. Article 17 of the Constitution strikes at caste based practices built on superstitions and beliefs that have no rational or logic in a modern developed society in India. And in another important leading case, and that is Prabhadri Gaundar versus State of Madras in 1973, and also in Devraj versus B. Padmana in 1958, which was a case of Mysore and decided by the Madras High Court, where it was observed that Article 17 has been implemented by the very Protection of Civil Rights Act, which is renamed in 1976, which was earlier known as the Untouchability Offence Act 1955. The principal object of Article 17 is to ban the practice of untouchability in any form. The expression refers to the social disabilities imposed on certain classes of persons by reason of their birth in certain caste, and does not cover social boycott based on conduct. A curious question was raised in the Madras case. The state legislature passed a law to improve the conditions of living of untouchables by providing for the acquisition of land to construct a colony for them. The argument was advanced that such a construction would result in the segregation of those persons and would not be in conformity with Article 17, but the argument was not accepted by their lordship. So, in last, that we have to discuss the very provisions enacted under the Act of 1989, and that is Scheduled Caste and Scheduled Tribe Abolition of Atrocities Act 1989, which almost a final arsenal of the union or the states in their hand to not only punish those who commit such atrocities on the scheduled caste and scheduled tribes on the very ground of untouchability and other such social evils regarding such segregated classes in our society. The very act also provide punishing such persons who commit such offenses or atrocities on the scheduled caste and scheduled tribes under the Act Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989. So, in this video, almost we covered the relevant decisions of the Supreme Court and the Madras High Court regarding their observation on the very concept of untouchability in practice and how it is now abolished under Article 17 of Part 3, which is a fundamental right, so it abolished its practice in any form, anywhere in India and declared it is an offense, and now it is also forbidden anywhere inside in India if it is in practice. And necessarily the very enactment of 1955, that is Untouchability Offence Act, as it declared not only it is an offence but also provides penalties and punishment for committing such an offence, and how it was renamed after the 1976 amendment as the Protection of Civil Rights Act, and the last important act that was enacted in 1989 was the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989. So all these are the relevant provisions which directly connected to the very Article 17, which declared abolition of untouchability, and untouchability is now considered as an offense wherever it is in practice in any form within the territorial jurisdiction of the Union. So, in our next upcoming video, we will discuss Article 18, which deals with abolition of